Every day in the USA, people find themselves in court.
We didn't foresee a 2-hour hearing.
I was guessing that.
Nobody said, tipped me off that it was going to be a little multifaceted like this,
Okay.
Jonathan.
Well, I know that we've,
it's
I think ours will go quicker, Judge, whenever you're
on
ready.
this hearing. There are some important issues that we have to address that may take a while. What do you want to do? It's almost 5 o'clock.
It is.
This hearing, I don't even know when it started, but it seems like days. But I think it was a couple hours, which is far longer than I suspected. There are some matters on Mr. Walker's case that are serious that we need to address, and I don't think we have the time right now to do this today.
I've been working on the appeal, so it's not like I've lost time while you were in your hearing.
Thank you.
Is there anything that you would like us to know? I know that Mr. Walker sold his truck. I know he's paid that money to the county. He's got one more check from the truck. I know he's working on his properties. Are there other things, Your Honor, that you want me to be prepared for?
Yeah. Well, stand by.
Yes, sir.
Okay. On a report that the court has received from the probation office and Ms. Hunter, who has been handling the supervision of Mr. Walker.
Okay.
He stated that he's allowing he sold a bucket truck for $5,000.
Correct.
And has allowed the buyer to make 3 installment payments. First one, $1,000 was received. So $1,500 was paid to the probation office. And that was, I guess, $1,000 from the payment on the truck and then the initial payment and $500 from some employment. Then he reported he received a second payment, $2,000, and paid $1,775 toward restitution on or about September 24th. About 3 weeks ago.
Yes, sir.
And he reported that GPS fees were going to be deducted of $225. And he reported that the final payment of $2,000 will be paid on or on/about 10/13/25, and he will apply the full amount to restitution. Has that been done?
I know that he's got that check, and I think he got it yesterday, and then he finally released the bill of sale to the guy buying it after he paid in full. So I think he has that check. I don't know if he's paid it. I think he got it yesterday. Mr. Walker, have you paid that last $2,000?
You know, to deposit the check in the bank. I was gonna do it today and then pay the restitution tomorrow.
Okay.
Well, he hadn't done it yet,
Yes,
but,
sir.
but he said he's going to get it in tomorrow.
Yes, sir. I think he got the check yesterday, is my understanding.
All right. So that's supposed to be done tomorrow morning?
Yes,
Is that
sir.
right? That's right. Mr. Walker. Here's some things that this court wants to address, and that is going to be dealing with these properties that Mr. Walker has promised he would sell too long ago that haven't been sold. And we're talking about the properties, Lafitte's Landing, lots 31 and 32. That's out at Pleasure Island, I believe. The Langham property. I call it Langham. That's but is that on Langham Road?
I think it's Langham Street, Judge, but I think you've got it right.
Okay. And then there's another, the Brandon Street property is the third one. And then there's a fourth piece of property. That's his homestead on Roland Road. But
Yes, sir.
these three other pieces of property have not been sold. And we've been working on this for years. So my concern about that is this is long overdue. Y'all haven't sold it, right? It's still up for sale?
It's still up to
It's
6.
still up for sale.
And Judge, I can update you, and I think this was all run by the probation officer or bond officer as well. There's been an attempt to drop the prices, and I'm happy to give you the drop if you don't have that information and attempt to get them sold.
It's not, that's not important to me anymore.
Okay,
I've got another idea.
okay,
I'm going to order you to sign these quitclaim deeds that I've already prepared. I've had enough. We've been doing this you've been on probation. You were on probation. This is 5 or 6 years now, since 2019. And restitution was ordered for over $1 million. And to this day, this is what I stuck my neck out. To this day, you've paid a grand total of about $7,800 in restitution. You spent more money in the jail on your frivolous candy and cookies and other things. More was spent in jail for your pleasures that weren't necessary, that could have been paid to the restitution. You made a choice. That was more important to you than getting your responsibilities taken care of.
May I say something?
no, you may not.
You have been on probation, and then the court has revoked your probation, but it lets you stay out on a bond, on an appeal bond on the court's revocation. You have paid a grand total of less than 1%, about 0.7% of what you owe to the people who are the taxpayers who are absorbing the costs of your theft, your pilfering. 1.17 million, you paid, that's what you owe, you paid off about 7,000. That's not even 1% over 6 years. Court doesn't find that satisfactory. You're able to work, and most importantly, it's so humiliating to everybody. We find it offensive that you'd spend more for candies and cookies than paying what you or have been proven responsible for. This $1+ million loss that the taxpayers had to absorb. That only hurt children who were trying to find an education at Beaumont School. I have quitclaim deeds here for you to sign. I'm going to order you to sign your interests over to Beaumont Independent School District because you haven't done enough, like you promised, like was ordered. I've got the proper quitclaim deed preparation for the Lafitte's Landing lots 31 and 32. That's Pleasure Island. I've got a quitclaim deed here for you to sign that you're ordered to sign on this Langham property. And also the property on Brandon Street. These are all quitclaim deeds where you are giving up your interests of ownership in these properties that have been ordered for you to liquidate that you have failed to do in 6 years. And those are going to be ordered, and the grantee, the recipient, will be the Beaumont Independent School District, and they can use those as assets, and they can try to sell and get liquidation on it because you have refused or failed to move on this to this court's satisfaction. And I'm not going to wait any longer. We're going to sign those and give those properties over to them. Any problems with that?
I would like to make legal objections, please.
You can go ahead.
My first objection would be to a lack of notice. I did know we were going to be here for a status conference. I was told by the court staff prior to today. I have not seen the quitclaim deeds, and so we would object to lack of notice. That dovetails with a due process objection and due course of law objection based on lack of notice that this was going to occur today. Also, under the Texas and federal constitutions, under the takings clauses related to due process, we object. Also, Fourth Amendment and Eighth Amendment, Judge. If I had time to research this, I'd be happy to put things in writing for you, Your Honor. And I don't want the court to think that I'm trying to stand in the way of restitution for Beaumont Independent School District. I'm just here asserting the rights of my client by making these objections.
But you understand the points I'm making. This has been an absolute total failure.
Your Honor, I'm going to be honest with you. I'm in the process of reviewing the various transcripts, so I'm not even caught up from the entire trial at this point.
Well, I'm intimately familiar with it.
I understand that, Judge.
Every step of the way. This has been going on since 2019, when a judgment was rendered, a decision was rendered, and we've been supervising probation for years. And I'd like anybody to tell me it makes sense that this court should be satisfied or not take action when 6 years have gone by and restitution had been ordered and 7,000, not 1% of the restitution has been paid over 72 months. That comes out to about $100 a month is what's being paid. I can do the math. About $100. The court did an unusual thing in this case. And this is the first time I had done it, and it may not be done again by me, but I allowed the defendant to have a bond set. And it was on this revocation of probation. And for the sole reason of paying restitution back. And that has miserably failed. We have had promises about this is going to be sold, that's going to be sold, and 6 years have gone by and nothing. This court has come up with a method of easily figuring this out. And this is taking the properties that he's claimed he's been trying to sell, and instead of him selling it, then it will be turned over to the people who have been the victims of this terrible high loss and theft, which every child in BISD and taxpayer supporting paying the taxes are having to bear. But it's just insulting to see that Mr. Walker hasn't spent more money that could have at least gone to restitution. It certainly wouldn't have balanced it, but used $8,000+ on cookies and candy while he was in jail. And since he has been released from that 180 days, he's been for years supposedly trying to accrue money to pay them back. We only have $7,800 of all of that time. That is an absolute failure from somebody who's ready, willing, and able and to work. And the math works out. It doesn't make sense. And it's insulting that you spent more on cookies and candy than paying your responsibilities of this loss. This court stuck its neck out and allowed you to be released on bond. And this court is ordering that these quit claim deeds be signed. And Mr. Landers,
Yes, sir.
your objection is noted.
Okay.
The court has ordered this. It's a condition of your bond while on release. You can either sign it or your bond is revoked right now.
Judge, just to be clear, I know you noted my objection. Those have been overruled. Is that correct?
Yes.
Okay.
Yeah.
And then I just want to make sure, because I can't see the whole courtroom. We are on the record. There is a reporter there. Okay. Thank you.
Always is.
To be careful, I should probably also object to the amendment of the bond conditions based on these exact same objections, though, Judge. Nothing new. I just want to be clear for the record.
Fine.
Okay.
Okay.
I'm sorry. I didn't mean to interrupt you, Judge. I'm sorry.
You speak. Go ahead, sir.
Okay. And then I would also note, I've got to believe there's a process whereby the representatives of the state who are there could initiate some sort of legal process to have this done, to cover a valid restitution order so that the judge is not put in this position. Or the adversary in these proceedings does this. And we think that with notice and proper briefing would be the correct way to do this.
No, sir. I don't know if you remember or you were involved back earlier in these proceedings, but this court entered a turnover order back in May of this year, ordering the defendant to turn over these properties. And y'all have had this was entered May 14th, June, July, August, September, October. 5 months have gone by. And y'all aren't surprised in this. This has been something that this court ordered 5 months ago. And it's in the court's turnover order in this case that I can surely send you a copy, but you know what's in the file. You should know what's in the file.
I believe it's in the reporter's or the clerk's record on appeal, Judge. And that's part of the appellate process that we're currently appealing as well.
All right. And it was this court entered this order in and it is clear. I walked this through that the Beaumont Independent School District has reaffirmed repeatedly that they are asking for restitution. and restitution was ordered in the amount of over 1 million, 1.2 million plus dollars. And a turnover order is contemplated under the Texas Civil Practices and Remedies Code and can be applied in this case. An order requiring a judgment debtor to turn over property to satisfy a judgment is a proper vehicle for a court to enforce its judgment, according to Texas decisions. Criminal courts may also resort to civil money enforcement mechanisms, such as what this court is doing, according to the Texas Court of Criminal Appeals. The Texas turnover statute provides judgment creditors with a procedural device to assist them in satisfying their judgment debts. And pursuant to the statute, a judgment creditor can seek court assistance in reaching a judgment debtor's property that is otherwise difficult to attach or levy by ordinary legal processes. If the judgment debtor owns property, the statute authorizes a court to aid a judgment creditor in satisfying outstanding liabilities by ordering the judgment debtor to turn over non-exempt property that is in the debtor's possession or is subject to the debtor's control. And this is what this court is doing, and that's Alexander versus Dubose, 540 Southwest 3rd at 581. This court, it's been 6 years since we have been hearing plans by the defense to sell these properties. I would think 6 years is more than a reasonable amount of time. This court is just not going to sit there and wait till we're all dead and gone before it acts in a way to facilitate the court's order and the judgment rendered by the a jury that found the defendant guilty. So this court ordered in its turnover order that the property of Lafitte's Landing, Brandon, and the lots on Langham and the 2 bucket trucks that the defendant had talked about be turned over. And I allowed the bucket trucks, because Mr. Walker had been saying that the bucket truck sales were in the midst of being accomplished and transferred and transacted. But we were told there'd be, there's still money, not today, but I'm told in a day or so, some more money will occur from the bucket truck transaction. But the real estate, this court it seems like I'm being dunned, is the term. Yes, don't worry. I'm going to get it sold. I'm going to get it sold. 6 years. And the court has had enough. The people have had enough. This Beaumont Independent School District can use these assets. These are 6 years old. He has had his trial. He appealed the verdict and it was affirmed. The court has found subsequent during his probation that he failed on probation for the reasons the court articulated, and then sentenced him to 9.5 years imprisonment, but nonetheless did an exception to the general rule that the court uses because of the vast loss to such an important entity that's important to this county and city and the children who are the direct recipients of school assets. And that is to give Mr. Walker an opportunity to, while appeal is being made on the revocation of probation, to continue to earn money and pay to the Beaumont Independent, back to the Beaumont Independent School District. you can, it's clear from this court's vantage point that frustration, we're past frustration. It's in, I'm going to repeat again, more money was spent at the commissary while he was in jail for cookies and candy than it was to this point in time paying the people back. That's so insulting. That defies logic of good faith. And then this land, we've been churning the sale on this for years. How somebody can convince me that it should be left into the hands of the defendant to sell on his good time when the value of it can not only be used immediately by the Beaumont Independent School District, the victim in this case, but it also will result in satisfaction toward the restitution payments of Mr. Walker, because he will be given fair credit toward his restitution. That
Does,
$1.1 million. It's very frustrating that 6 years have gone by and it's clear we're not getting anywhere.
I had a question about that value. Will this satisfy the remaining restitution, Judge?
No, it won't. It'll satisfy what is a fair value toward it, and that's what I believe the law provides. But this is not; these three properties are not worth $1.17 million. Everybody knows that. The defendant has given a value on it already, and it doesn't get near that. But it's several $100,000, I think.
Well, how do we calculate that based on the court's order, Judge?
It was, I think there are values in here already.
Okay.
But in all fairness, and I'm sure the law sets this, he is entitled to be fairly given credit towards the fair value for it. Now, we all know it's what a willing buyer is and a willing seller. He's saying he can't sell it, but he bought it and he's got it valued at $200,000 and $300,000, these properties. So the court is not going to play hardball on the value. I think we can get someone to make a determination of what is fair and fair market value, even though Mr. Walker is having trouble selling it. The property can be turned over to BISD, and they might be able to use it themselves for their own as their own assets. Especially at Pleasure Island, who knows? That might be a place where they can use for some of their school methods and teaching and activities. I don't know, but it's assets, and the BISD is not getting fairly compensated right now. We are taking inches as steps, and we need to go miles here. And 6 years have gone by. That's just far too long. A reasonable amount of time has passed. This court has lost its patience on waiting for Mr. Walker to make fair recompense that the jury has determined is proper. And once again, not even 7/10 of 1% has been repaid on this loss. And I really haven't restricted Mr. Walker in any way, except for the 180 days he had to stay in jail. I haven't restricted him of using all of his abilities and opportunities toward getting these sold, and nothing's being done. this court is not going to spin the wheels of justice any longer. We're taking affirmative action. This is the order that this court is ordering these documents to be signed. And in all fairness, though, to Mr. Landers, it wouldn't be fair to you for me to punish somebody for not signing them right now when you haven't had a chance to look at them. You know,
Thanks, sir.
yeah, that's just, I'm not going to be that way. I'm going to give you a fair amount of time. Whatever, just tell me what you need. Think about it. Okay.
What I was gonna ask, if it's okay, Judge.
I'm just,
Yeah.
they're 2-page instruments. Each of them are 2-page instruments. And I can get that to you to look at just as, and review as soon as possible. And I'm going to give you a reasonable amount of, time that you think you need. I don't, want to just blindside you on this, but from this court's standpoint, it far too long has passed without reasonable advances toward paying back this enormous loss, which such a small amount that has been achieved, a small amount. It is not reasonable, and the court's going to take action. Go ahead.
Your Honor, I know my objections have been overruled. I do appreciate a little time very much. What I would ask, if the court would oblige me, is just even a short written order. Maybe attached to those so that I can then do the research, and I'll tell the court to give you an update on the appellate proceedings. Today I filed a brief, and Friday I filed a brief. And in different cases, I've started reviewing the record in Mr. Walker's case. And I think as I'm doing that, I'd like to look into your prior set aside order, all the things that you know that I don't know, Judge. If I could have a couple of weeks to figure this out and then give Mr. Walker his options, that's what I would request, Your Honor. Maybe 2 or 3 weeks.
2 or 3.
Yes, sir.
What do you want? I'll give you.
Three would be great, because that's about when the appellate brief is due.
All right. I'm gonna give you 3 weeks from today.
Okay.
Thank you.
Yes,
Please.
sir.
But this court's taking a firm stance here, and but I'm going to give you a chance to look at it. I'm certainly going to listen to what you have to say, but it's you can imagine. I'm close to this, and truly, $7,800 in 6 years, not even 1%. That defies logic. That shows a complete lack of vigor in seriously handling the payment of this restitution. And I believe even the defense has given evaluations that I believe are several $100,000 on these 3 properties. And I've got them here somewhere, but those are values that I believe the defense even claimed, that Mr. Walker claimed this is what they're valued at. It's not being sold for that. They can't sell it, but
I think it's around 400,000 if you were to add them all up. And as you said, they haven't sold, Judge.
But that's 400. That can be $400,000 of value that can satisfy the judgment to a degree, to a substantial degree, and also get something in the hands of that are of value to the Beaumont Independent School District for the whole reason this court allowed Mr. Walker an exception to the general rule, and that is to be allowed bond while he was appealing the revocation of probation. solely to get restitution. And we're, once again, we're getting 100 a month. That's what it's averaged. That's poor. That does not satisfy this court. And I want these properties moved over into the hands of the people who have been victimized, the entity that's been victimized according to the jury verdict, and be used to the education of the children, which has always been this court's fundamental goal in trying to get justice served in this case. I married a school teacher, a superintendent. She was a superintendent. Nobody's intimately more concerned with the importance of education to children than me. And one of my children attended BISD. It's a great asset in Southeast Texas, maybe the greatest next to Lamar University as education. Taking 1.172 million from their assets that Mr. Walker was deemed to be guilty of, and paying back just 7,800 over the last 6 years since he was held accountable does not make any sense at all. So you can see, Mr. Landers, there's a sense of urgency in what I am doing. He's had enough time. I'm going to give you 3 weeks.
Judge, about the date, I don't know if the court has docket every day, that the Friday of November 7th. I don't want to suggest, but I'm pretty sure that I'd be wide open that day, so I could come out there in person and everything, if that's okay with you, Judge.
That's okay. Lacey?
Yep.
What does that look?
Yeah, we're good.
That looks good. That looks good, John.
Okay, and I'll just look for a time, and I don't have to pick my son up that day either, so I can come afternoon or morning, Judge.
The state of Texas has an interest in this. The district attorney's office has been very sensitive toward the victimization in this case, as they well should be. Are y'all going to be available here on the 7th of November? Okay. Sure. All right.
Thank you, Judge.
Okay. Then we're going to do that. I'll hold things in abeyance then for 3 weeks. But this court expects some changes to be made on or before that day. Now, I've got Mr. Walker here. He's on bond. I don't like sticking my neck out when there has been such a paltry return, as completely different from what has been promised. I'm inclined to allow Mr. Walker 3 more weeks so he can talk with you. But this is I intend to revoke the bond, so he would be treated like everyone else, especially in light of the fact that the promises that have been made to this court have not been fulfilled. That's what we call fair.
I apologize. I guess I don't apologize, Judge, but I'm an appellate attorney mostly, and so
Yeah. Fight for your client.
I would like some sort of written notice to put us on notice of what, if we're going to have a revocation hearing, kind of like we saw earlier with your motions to adjudicate. So I know exactly what I'm defending against.
Right now, this court can revoke his bond for good cause. And this court has already articulated what I think is good cause, but I'll let you, I'm not going to blindside you. You got 3 weeks to prepare. And I would urge Mr. Walker, if he wants this court's to have favor with him based upon his track record, something has to turn immediately toward recompense to the victim in this case, the Beaumont Independent School District. I've already said this was the only reason, I've said this numerous times on the record, this was the only reason he was being treated differently. It's because these assets are there. But it doesn't matter if they don't get turned over. I've ordered them to be turned over in the turnover order, and that hadn't been done. This is 5 months old. This court's tired of its orders not being followed in this case when we have children's education on the line. Nothing seems more important to me than that.
Yeah, thank you, Judge. If there's anything else.
What else, Mr. Walker, do you have that you're working on with your attorney here for assets to be paid back? You got this bucket truck. What else?
We do have another bucket truck, just so you know, Judge. It's currently for sale in the same format that the previous one was. It's been for sale. Second bucket truck. There is a new contract for working on the horizon, and there's one going on right now that should knock out close to another 1,000, probably minus the 225 ankle monitor fee in the next few weeks, I think.
State of Texas, anything y'all want to add? I can sense the frustration.
My reservation is I didn't know this was going to happen today, so I feel
You're unprepared.
I feel unprepared.
Is 3 weeks going to be good enough
Yes,
time
yes,
to
sir.
be ready to respond to all of this?
Yes, sir.
All right, this is, you can see what this court is inclined to do unless a miracle happens. But this has taken far too long. This court's going to move on its own and move those assets one way or the other. But this court feels confident I have the authority to order these to be done. The law wouldn't make sense otherwise. After years and years of assets that are valued so highly for no successful transaction to be accomplished, then in lieu of that, turn them over to the recipient, the victim, let them use those assets and sell those assets. At least they finally get something, a portion of this 1.172 million loss repaid, which has been the foremost concern of this court.
All right, Judge.
All right. 3 weeks.
Thank you.
That is all. We are in recess.
Thank you very much.
Yes, sir.